This is Dejobnik, your command post for clarity and perspective.
I thank Ms. Radwan, and I invite Mr. Omri Sender to address the court. You have the floor.
Thank you. Madam President, members of the court, it is an honor to appear before you today on behalf of the State of Israel. It falls to me to address the condition of risk of irreparable harm and urgency. This third condition is, of course, dependent on the two preceding ones. Professor Shaw and Ms. Radwan have already shown that the provisions relied upon by the applicant do not afford, even prima facie, a basis on which this court's jurisdiction could be founded. They also showed that the rights asserted by the applicant cannot be regarded as plausible. It follows that the irreparable consequences cannot, in the present case, be caused by the alleged disregard of rights under the Genocide Convention. Again, this is not at all to say that the humanitarian situation arising from the present armed conflict is not grave. Civilians have been severely affected by the hostilities instigated by Hamas. Its systematic strategy of prosecuting war from under and within the civilian population exposes civilians to great risk, and it has brought about great suffering. Israel has done and is doing a great deal to alleviate this suffering in very challenging circumstances. In this regard, the factual account provided by the applicant is once again entirely one-sided. The application and request run no less than 84 pages, but they make hardly any mention of the extraordinary efforts undertaken by Israel and by a host of other states and international actors to improve the humanitarian situation. We again heard virtually nothing from the applicant on this issue yesterday. But this is a critical factor in the request before you. As Ms. Radwan has shown, it frustrates any attempt to establish the necessary special intent for genocide. It also bears upon the third condition established in your case law. Madam President, members of the court, we know from your case law that the power of the court to indicate provisional measures will be exercised only in exceptional circumstances. There needs to be, as you have said, a real and imminent risk that irreparable prejudice will be caused to the rights claimed before the court gives its final decision. Your order in the Myanmar case, in which the Genocide Convention was also invoked, suggests that the adoption, and I quote, of concrete measures aimed specifically in recognizing and ensuring the right, end of quote, of the group in question to exist would mean that irreparable harm and urgency cannot be established. Precisely such concrete measures have been taken by Israel, which has been facilitating the provision of more and more humanitarian assistance for people in need throughout the Gaza Strip. These steps have not only been increasing so as to meet the developing situation on the ground. They are continuously undertaken specifically in order to prevent harm to the civilian population. These efforts have had an impact. Just last week, for example, with the assistance of the World Food Programme, a dozen bakeries reopened with the capacity to produce more than 2 million breads a day. The World Food Programme has said the delivery of flour, salt, sugar, and yeast continues so as to enable more bakeries to reopen, increasing accessibility and affordability for thousands of families. And since the applicant mentioned yesterday the number of trucks entering Gaza each day before and after the war, the accurate average number for trucks specifically carrying food is 70 trucks a day before the war and 109 trucks a day over the last 2 weeks. All this information may be found in your judge's folder. Access to water has also been a priority. As with food supplies, there is no restriction on the amount of water that may enter Gaza. Israel continues to supply its own water to Gaza by 2 pipelines. It facilitates the delivery of bottled water in large quantities, and it repairs and indeed expands water infrastructure that has been damaged by the fighting. An additional water pipe bringing water into southern Gaza from Egypt began operating a few weeks ago. Access to medical supplies and services is also growing. Israel has so far facilitated the establishment of 4 field hospitals and 2 floating hospitals. The establishment of 2 more hospitals is underway. Israel is facilitating the entry of medical teams into Gaza, as also vaccinations, including in cooperation with UNICEF. Ill and wounded persons are being evacuated through the Rafah border crossing to Egypt, the United Arab Emirates, Turkey, Qatar, and Jordan. Tents and winter equipment are being distributed as well. The constant delivery of fuel and cooking gas is also facilitated. According to official data, again in your judges' folders, from 8 December, the amount of fuel entering Gaza has doubled and currently stands at 180,000 liters a day. This is a target amount requested by the UN itself. Since 21 December, the amount of cooking gas entering Gaza has also doubled, now standing at an average of 90 tons per day. Details of this kind concerning the various ongoing humanitarian efforts are updated every single day on a designated English website of COGAT, the unit in the Ministry of Defense in charge of monitoring the humanitarian situation. When pressing needs are identified, solutions are soon coordinated. A great effort is indeed invested in eliminating bottlenecks so as to improve the entrance and distribution of aid, notwithstanding Hamas constantly stealing it. As you have heard, a joint operations room involving Israel, Egypt, the United States, and the UN operates daily to solve in real time logistical difficulties. Israel also coordinates with various UN agencies and the ICRC to address their own needs. On 15 December, Israel decided to open its crossing at Kerem Shalom with the express intention to improve and upgrade the delivery of humanitarian assistance to Palestinian civilians in Gaza. That part of the government's decision is in your judges' folder as well. This has eased congestion at the Rafah crossing and helped facilitate the provision of greater amounts of aid. Israel facilitates air routes as well for parachuting aid directly into Gaza. Facilitating a maritime corridor is currently being considered with other states. Madam President, members of the court, again, these are just some examples, but they show that Israel, no doubt, meets the legal test of concrete measures aimed specifically at recognizing and ensuring the rights of the Palestinian civilians in Gaza to exist. It has been the daily work of numerous Israeli officials, of various agencies, to ensure that these and other steps are effectively carried out at a time when they and their families are themselves under constant attack. a determination that the multilateral, large-scale humanitarian effort is lacking, or that scaling up access of humanitarian relief to Gaza would be of no avail, as the applicant would have you believe, should not be made lightly. Madam President, members of the Court, two additional elements warrant your careful attention. They too suggest that the condition of urgency is not as easily met as the applicant would have you believe. First, the scope and intensity of the hostilities has been decreasing. Israel's defense minister said last week that Israeli forces would be shifting from the intense maneuvering phase of the war toward, and I quote, different types of special operations. This statement, made in an interview to international media, is found at tab 16A of the volume submitted. This week, on 8 January, the spokesperson for the Israeli military confirmed that the Israeli campaign had already started a transition to fewer ground troops and fewer airstrikes. The war shifted a stage, he said. As you will see in tab 16B of the volume, he spoke of a new and less intense phase of fighting. He specifically mentioned that Israel will continue to reduce the number of troops in Gaza. 5 brigades, consisting of thousands of soldiers, have already been withdrawn from the territory. Second, the UN Security Council has only recently adopted a resolution for the specific purpose of alleviating the humanitarian situation. By Resolution 2720 of 22 December, which is found at tab 16C of the volume, the Council demanded the immediate and unconditional release of all hostages, as well as the delivery of humanitarian assistance at scale directly to the Palestinian civilian population throughout the Gaza Strip. More specifically still, the Council requested the Secretary General to appoint a senior coordinator in order to establish a UN mechanism for accelerating the provision of humanitarian relief consignments to Gaza. Contrary to what we heard yesterday, this resolution does not, and I quote, remain unimplemented. Close quote. A senior coordinator has been appointed and indeed began her work. The Council remains actively seized of the matter. Israel, for its part, is already working with the senior coordinator, and it has just this week coordinated the entrance of a UN delegation into northern Gaza in order to evaluate the situation and map the needs for a future return of Palestinian civilians. I recall in this connection that in the Aegean Sea case, the court found that it was not necessary to indicate provisional measures where the government in question showed willingness to act in accordance with the recommendations of the Security Council concerning the matter before the court. All these recent developments indicate that the facts as they presently exist do not call for awarding interim relief. They also suggest that the difference between the present case and earlier cases that have come before you are very clear. Finally, the lack of urgency within the meaning of the court's case law is further demonstrated by assurances provided before you today by Israel's co-agents. They could not be clearer in stating that Israel remains bound at all times by its international legal obligations. Needless to say, this includes Israel's obligations as a state party to the Genocide Convention. The applicant will have this court say that it cannot take the word of a state. That would be not only unfortunate, it would also be contrary to the law on unilateral declarations of states. Unsurprisingly, your consistent case law suggests that assurances of the kind offered by Israel may well render the indication of provisional measures unnecessary. Madam President, members of the Court, the conclusion is that the condition of irreparable prejudice and urgency cannot be met. It is Israel and its citizens who would risk irreparable harm if the request of South Africa were to be granted. Madam President, distinguished members of the Court, that concludes my statement. I thank you for your kind attention, and I ask that you now invite Mr. Staker to the podium.
I thank Mr. Sender, and I now invite Mr. Christopher Staker to take the floor. You have the floor, sir.
Madam President, Mr. Vice President, members of the Court, it's an honor to appear before you again and to represent the State of Israel. You've now been addressed on why the conditions for provisional measures are not met. That being so, there's no need to examine the 9 particular measures that South Africa requests. Nonetheless, for completeness, I will address each in turn and show that their terms are unwarranted in any event. They go beyond what is necessary to protect rights on an interim basis and therefore also have no link with the rights sought to be protected. I start with the first and second requested measures. These would require immediate suspension of Israel's military operations in Gaza. This request is frankly astonishing. A request is made by a state not party to an ongoing conflict for provisional measures requiring unilateral suspension of military operations by one party to the conflict only, leaving the other party free to continue attacks which it has a stated intention to do. South Africa cannot argue that similar measures were granted in the Russia genocide case. That case was fundamentally different. In the Russia case, the legality of the military operation itself was in issue by reference to the Genocide Convention. Russia had claimed that its military operation was to prevent and punish genocide being committed in Ukraine. The court found it doubtful that the Genocide Convention authorizes a unilateral use of force in the territory of another state, and plausible that Ukraine had a right not to be subjected to military operations by Russia for that purpose. The result, provisional measures could protect a plausible right not to be subjected to military operations. In this case, Israel does not rely on the Genocide Convention or prevention of genocide to justify its operations. The lawfulness of the operations themselves does not involve any interpretation, application, or fulfillment of the Convention over which the court has jurisdiction. As jurisdiction in this case is based solely on Article 9 of the Convention, the court cannot find that South Africa or Palestinians in Gaza have a plausible right of the kind in the Russia case. Article 41 of the statute empowers only such provisional measures as the circumstances require to preserve the respective rights of either party. In the Russia case, a suspension of military operations might have been necessary to preserve a right not to be subjected to military operations. But in this case, the right in issue is South Africa's claimed right to ensure observance of the Genocide Convention. It's absurd to suggest that the only way to ensure observance of the Genocide Convention in a military operation is to prevent the operation from being conducted at all, in order, according to South Africa, to secure the humanitarian response and avoid yet more unnecessary death and destruction. That goes beyond preventing genocide. South Africa appears to argue that the military operations as such are genocidal. But how has South Africa established a plausible claim that this is so? Mr. Hassim argued only that it's plausible, quote, that at least some, if not all, of these alleged acts fall within the Convention's provisions. How does at least some acts turn into the military operations as such? The pictures shown yesterday of various individual incidents, whatever they may or may not say about those incidents, are not evidence of the intent of the military operations as a whole. Professor Shaw has addressed you on why the statements of holders of official positions relied on by South Africa do not establish a plausible claim of genocidal intent. The inevitable fatalities and human suffering of any conflict is not of itself a pattern of conduct that plausibly shows genocidal intent. These provisional measures are therefore not within the Court's power under Article 41 of the statute. They go well beyond anything required to preserve the specific rights in issue, namely the observance of the Convention in military operations. They seek instead to shut down the military operations themselves. The requested measures seek to reverse the Bosnia case. When provisional measures were ordered in that case, the armed conflict was still in progress. The allegations in that case were similar to those made in this case. Bosnia and Herzegovina specifically requested a provisional measure requiring Yugoslavia to cease and desist from any and all types of military or paramilitary activities against the people, state, and government of Bosnia and Herzegovina. But the Court did not grant it, even though, unlike in this case, an ongoing genocide was said to be in progress on the territory of the very state seeking provisional measures, and both parties to the conflict were parties to the case. The Court said expressly that it refused because such a measure would be for the protection of a right that could not form the basis of a judgment in exercise of jurisdiction under the Genocide Convention. There is no reason to depart from that case law. In any event, provisional measures cannot be indicated if, as in this case, they would cause irreparable prejudice to the respondent or are out of proportion with the protection that they're intended to give to the applicant. The fact is that provisional measures impose burdens on the party to which they are addressed in order to protect potentially non-existent rights of another party. It would be contrary to the sovereign equality of states for such burdens to be imposed without regard to their effects on the state to which they are addressed. As Judge Abraham said in the pulp mills case, in a request for provisional measures, the Court is faced with conflicting rights claimed by the respective parties and cannot avoid weighing those rights against each other. In the Financing of Terrorism Convention case, Judge Tomka said that the Court, when considering requests for provisional measures, is expected to weigh and balance the respective rights of the parties. He went on to note, citing specific examples, that this requirement has been observed in the Court's practice. The Court has made clear in other provisional measures orders that it must preserve the respective rights of both parties. Its established jurisprudence is that Article 41 of the statute, quote, has as its object the preservation of the respective rights claimed by the parties, unquote. That is to say, both parties. The respective rights to be preserved are thus not only the plausible but yet to be determined rights claimed by the applicant, but also the plausible and yet to be determined rights of the respondent to engage in conduct that provisional measures would restrain. Other international dispute settlement fora also balance the interests of both parties when ordering provisional measures. Already a century ago, a mixed arbitral tribunal recognized a principle that the possible injury to the addressee of provisional measures must not be out of proportion with the advantage which the claimant hopes to derive from them. The Institute of International Law has now recognized a general principle of law that international and national courts and tribunals may grant interim relief and, as a requirement for such measures, that the risk of injury to the applicant must outweigh the risk of injury to the respondent. This principle is also recognized by other international dispute settlement mechanisms. Other principles applied when indicating provisional measures are that none of the parties can be put at a disadvantage, that measures should not go beyond what is necessary to achieve their end, that the measures must not cause irreparable prejudice to the rights of the respondent, and that any impression of bias must be avoided. These principles are all aspects of the most basic and elementary duty of the court to ensure equality between the parties. Article 41 of the statute states that provisional measures are to preserve the respective rights of either party. It does not refer solely to the rights of the applicant for provisional measures. Not to apply such principles would be absurd. Suppose that the Genocide Convention and the court had already been in existence during the Second World War, and that the Allied powers were all parties to the Convention without reservation, while the Axis powers were not. Suppose that a neutral state had brought proceedings against the Allied powers, alleging breaches of the Genocide Convention and their conduct of hostilities, and requesting provisional measures requiring the Allies to cease hostilities immediately, invoking pictures of civilian fatalities and suffering in the war as a plausible claim. Such provisional measures would have required the Allies to surrender to the Axis powers, even though the case against them might later have been held to be wholly unfounded, without any consideration by the court of whether genocide was being committed by the Axis powers. Provisional measures must have their limits. Could a provisional measure require a state to change its government or to vote in a particular way in the General Assembly? The answer must be no. Can provisional measures require a state to refrain from exercising a plausible right to defend itself? The answer must be the same. In this case, the balancing of interests must take into account the following. First, Hamas is considered to be a terrorist organization by Israel and other states. Second, it's undisputed that on 7 October, Hamas committed on Israeli territory a large-scale terrorist attack. This is continuing. Third, Israel's right to conduct the military operations in exercise of its right to defend itself has been recognized internationally. Fourth, Israel is committed to complying with international humanitarian law. And fifth, Israel is taking steps to alleviate the humanitarian situation. The co-agents and other counsel have and will address you on this. Sixth, this is not a case where provisional measures could require both parties to a conflict to exercise mutual restraint. They would not be binding on Hamas. Seventh, Hamas has made clear its intention to carry out continuing attacks against Israel and its citizens. Eighth, provisional measures would deprive Israel of the ability to contend with this security threat against it. More rockets could be fired into its territory, more of its citizens could be taken hostage, raped and tortured, and further atrocities could be conducted from across the Gazan border, but provisional measures would prevent Israel from doing anything. Ninth, provisional measures would end attempts to rescue those already taken hostage. 10th, suspension of military operations would give Hamas space to preserve and build its capabilities, enabling it to pose an even greater threat and to use remaining hostages as bargaining chips. If granted, the result would be this: an organization recognized internationally as terrorist has committed a terrorist atrocity in the territory of a state, and a third state now seeks an order from this court that would prevent the attacked state from responding, but which would impose no obligation on those responsible for the attack. The requested measures would not put an end to the conflict, but only to military operations by one party to the conflict. These measures would assist the other party and encourage the commission of further terrorist attacks. In this respect also, the Russia case is fundamentally distinguishable from this case. Provisional measures should be a temporary shield to preserve claimed but as yet unproven rights pending a decision on the merits. Instead, they're being used here as a sword to give an advantage to one party in a conflict over another. The irreparable prejudice to Israel is obvious, so is the lack of proportionality. Madam President, members of the court, Israel's position is that there is no conceivable basis on which the first two provisional measures could be ordered. I turn then to the third requested measure. This would require Israel to take all reasonable measures to prevent genocide. This is analogous to the first provisional measure in both the Bosnia case and the Myanmar case. There are two further objections to this measure. First, its wording is not confined to the current military operations in Gaza. It's expressed to apply in relation to the Palestinian people generally. This opens the possibility to later claims that actions by Israel having nothing to do with Gaza are in breach of this provisional measure. While the Convention obligation to prevent genocide may not be confined to current operations in Gaza, the subject matter of this case is. There is no justification for the provisional measure to extend beyond the claim itself. This particular objection applies also to the fourth and seventh requested measure. A second objection is that this third provisional measure would impose the same obligation on South Africa as well. No reason is given for this. The other requested provisional measures do not apply to South Africa. Why this one? Is South Africa saying it may fail to comply with its obligation to prevent genocide if not compelled to do so by a provisional measure? Unlikely. Rather, through this provisional measure, South Africa appears to seek a special mandate from the court to act internationally in relation to Palestinian issues on the basis that it seeks to prevent genocide. Indeed, if South Africa's right to bring these proceedings was disputed, South Africa might argue that this provisional measure gives it the right. However, provisional measures cannot confer special mandates on states, and no justification for doing so is established in any event. The third provisional measure should therefore not be granted. I move on to the fourth requested measure. This would require Israel to desist from committing acts within the scope of Article 2 of the Convention. There are fundamental objections to this measure. First, it has no counterpart in the provisional measures ordered in the Bosnia and Myanmar cases. What's the need for this special novel measure? No explanation is given. Second, it uses the word desist, which implies that violations of the Convention by Israel are occurring. It seeks an implied ruling on the merits. In the Bosnia case, you declined to grant a provisional measure requested by Bosnia and Herzegovina that Yugoslavia must cease and desist from all acts of genocide. You should also refuse this request. It's one thing to call on a state to comply with its obligations under the Convention. It's quite another to imply that a state has failed to do so. While provisional measures are without prejudice to the merits, Such an implied finding will tarnish the reputation of the respondent state, which is not only unprincipled, but also unnecessary within the meaning of Article 41 of the statute to protect claimed rights on an interim basis. Third, this measure refers to acts within the scope of Article 2 of the Convention. Now, although an act is not within the scope of Article 2 unless it's committed with genocidal intent, the proposed wording leaves scope for South Africa subsequently to argue that the words mean only the acts themselves, whether committed with genocidal intent or not. On that interpretation, the effect would be to shut down Israel's military operation. Every killing or wounding of an opposing combatant by Israeli forces, every collateral civilian casualty, no matter how lawful under international humanitarian law, would be a breach of this provisional measure. Even security checks by Israeli forces of humanitarian aid entering Gaza, in accordance with international humanitarian law as recognized by Security Council Resolution 2720, might be argued to be a breach. The request for this measure should be rejected for the same reasons as the first and second measures. I next address the fifth requested measure. This specifies types of acts to be regarded as deliberately inflicting conditions of life calculated to bring about physical destruction for purposes of the fourth provisional measure. This measure is also objectionable. First, it's not a freestanding measure, but an elaboration of paragraph C of the fourth measure. If the fourth measure is not granted, then the fifth measure falls away. Secondly, no analogous provision is found in the provisional measures order in the Bosnia and Myanmar cases, and no special need for such a new measure is established. Third, it again uses the word desist. Fourth, it seeks further impermissible implied rulings on the merits. For instance, it refers to so-called expulsion and forced displacement of Palestinians from their homes. This is an apparent reference to Israel's practice of issuing calls for civilians to temporarily evacuate areas of intense hostilities, which is in fact a measure to mitigate harm to civilians. This measure thus seeks the court's ruling that evacuation calls amount to expulsion and forced displacement of Palestinians from their homes. Does South Africa suggest that Israel should cease giving warnings to civilians before military operations? How would that protect the rights that South Africa claims? Similarly, paragraph C of this measure seeks the court's ruling that damage to buildings in military operations, presumably even when lawful under international humanitarian law, amount to the destruction of Palestinian life in Gaza. Overall, paragraphs A to C of this measure, read together with paragraph C of the third measure, seek the court's ruling on the merits that evacuation calls, the current humanitarian situation and damage to buildings all amount to deliberately inflicting on the group conditions of life within the meaning of Article 2C of the Convention. The reality is that the conflict and the humanitarian situation cannot be resolved overnight. This provisional measure seems designed to ensure that Israel will be in breach of it as soon as it is made. Its sole purpose seems to be to prejudice the merits, not to preserve rights on an interim basis. It should also not be granted. The sixth requested measure incorporates two separate measures. The first of these would require Israel to ensure that its military and organizations and persons subject to its control do not commit acts falling within Articles 2 or 3 of the Convention. It's analogous to the second provisional measure in the Bosnia and Myanmar cases, respectively. But an objection to this is the reference to any irregular armed units or individuals that may be directed, supported, or otherwise influenced by Israel. This wording has simply been copied from the second provisional measure in the Bosnia and Myanmar cases. However, in those cases, the applications instituting proceedings expressly allege the existence of irregular armed units. The reference is inappropriate in this case. There's no suggestion of forces other than the Israel Defense Forces on whose commitment to international humanitarian law you have and will be addressed on today. The second part of the sixth provisional measure contains an obligation to punish genocide. No such provision was included in the Bosnia or Myanmar Provisional Measures Order. Punishment of genocide is not something that needs to be done urgently in order to protect claim rights on a provisional basis. This measure should also not be granted. The seventh provisional measure also comprises two separate measures. The first would require Israel to take measures to prevent destruction of evidence. The Court has indicated such a measure on two recent occasions, but declined to do so on two other recent occasions, despite a specific request by the applicant. In the cases where it was granted, the application for provisional measures specifically alleged that evidence was being destroyed or concealed. In this case, South Africa makes just a bare assertion that there are serious concerns about the destruction of evidence and its effect on future investigation into crimes, and a hampering of scrutiny of Israel's actions. South Africa appears to suggest that the effects of the military operations themselves amount to destruction of evidence, making this yet a further provisional measure, effectively seeking a suspension of military operations. The granting of this measure would imply that there is some reason to suspect concealment of evidence when in fact none has been identified. This again would be an unprincipled and unnecessary tarnishing of reputation. The second part of this measure would require Israel not to impede access to Gaza by fact-finding missions, international mandates and other bodies. However, it is noted first that access to Gaza from Egypt is under the control of Egypt. Secondly, Israel has no obligation under international law to allow access from its territory into Gaza. Thirdly, a provisional measure to this effect was requested by the applicant in the Myanmar case, and it was not granted by the Court. The need for this measure has not been established. The eighth requested measure would require Israel to submit regular reports to the Court on measures taken to give effect to the provisional measures. Provisions for such reports were made in two recent provisional measures orders, but on four other occasions it was refused despite being specifically requested by the applicant. This shows that such measures are not routinely granted. They've been granted occasionally when specific action has been indicated. In Armenia versus Azerbaijan, the Court said that a report was necessary in view of the specific provisional measures it's decided to indicate and in light of the undertakings made by the agent of Azerbaijan. South Africa does not justify the inclusion of such a measure. There is no shortage of publicly available Israeli material and reports about the present situation in Gaza. Finally, the ninth requested measure is a non-aggravation measure. On two recent occasions, such a measure was specifically requested by the applicant but not granted by the Court. Again, such a measure is not the norm, and again, South Africa does not justify its necessity. Provisional measures for non-aggravation have been indicated in cases where both parties have been directly involved as actors in the facts of the case, and the provisional measures have always applied equally to both parties. Thus, in Myanmar, the Court declined to grant such a measure. An obligation of non-aggravation cannot fairly be imposed on only one party to a case or only one party to a conflict. If the proposed measure was granted, South Africa would remain free to aggravate its claim dispute with Israel, and Hamas would not be impeded from escalating the conflict with Israel. The only purpose of this provisional measure appears to be to prevent Israel from responding to any such escalations. Again, there's no justification for this measure. Madam President, members of the Court, that concludes my arguments on the inappropriateness of the specific measures requested by South Africa. I thank you for your careful attention. I invite you to call on Mr. Noam, co-agent of Israel, to conclude Israel's arguments.
I thank Mr. Staker, and I now invite the co-agent of Israel, Mr. Gilad Noam, to address the Court. You have the floor, sir.
Madam President, members of the Court, Counsel have shown that the applicant has failed to make the case for the indication of provisional measures. More specifically, 1. The Court lacks prima facie jurisdiction, as the applicant has not shown any dispute between itself and the respondent at the time the application was submitted. Indeed, it tried to mislead the court into believing that one had existed. 2, the applicant has failed to meet the condition of plausible rights to be protected in the present circumstances. 3, the simple reality is that the events which are the subject of these proceedings are occurring in the framework of a war instigated by Hamas, governed by the legal framework of international humanitarian law. They do not fall within the remit of the Genocide Convention. 4, the standard of irreparable harm and urgency is not met either. Israel is constantly taking concrete steps, together with others, to address the humanitarian situation in Gaza. 5, finally, we have shown that each of the provisional measures sought are unwarranted and prejudicial. All this requires that we give attention to 2 fundamental matters arising from these proceedings. The first is that the applicant seeks to portray an image of Israel as a lawless state that regards itself as beyond and above the law. The applicant paints an image of Israel as a state in which the entire public service, military, and society have in concert discarded Israel's long-standing commitment to law and morality and become singularly consumed with destroying an entire population. That is patently false. I can attest to that firsthand as the Deputy Attorney General for International Law. In this position, I regularly advise the government on issues of international law, including humanitarian law. This has not changed since October 7th. The conflict with Hamas poses serious operational and legal challenges. In conducting close-quarter urban combat while mitigating harm to the surroundings, in seeking to put a stop to Hamas military use of hospitals while minimizing disruption of medical services, in helping civilians leave areas of the most intense fighting while Hamas forces them to stay in the line of fire, in facilitating the provision of aid when that aid is constantly stolen by Hamas to sustain its military efforts, in balancing humanitarian considerations with the need to act forcefully against an adversary that still fires rockets deep into our country and holds our citizens hostage. As the authority responsible for international law advice to Israel's government and cabinet, I can attest that in contending with these challenges, Israel remains committed to international law. When the cannons roar in Gaza, the law is not silent. This has been the case since Israel's establishment in 1948, the same year the Genocide Convention was adopted. Israel's commitment to the rule of law has remained steadfast throughout our history, despite the complex challenges we face as a nation. It reflects the commitments made at the time the state was established, as reflected in our Declaration of Independence, which makes express reference to the principles of the Charter of the United Nations. In 1948, too, Israel was at war, forced upon it. Yet, despite being engaged in a war for its survival, the young state gave great importance to immediately establishing an effective, independent, and impartial legal system. Indeed, one of the first steps the newly formed IDF took in the midst of a war was to establish a military justice system. This system has evolved into an integral part of the institutional structure of the IDF. Thus, the IDF Military Advocate General holds the highest rank in the IDF, save the Chief of Staff, and is institutionally independent from the military chain of command. Her staff, including international law experts, are interwoven into all aspects of the military's activities. They provide legal training and education. They are involved in the drafting and preparation of military plans and doctrines. And they provide ongoing legal advice on a range of issues, including targeting, weaponry, and obligations towards the enemy's civilian population. This remains the case in the current conflict. The civilian legal system, including my department in the Ministry of Justice, serves as an avenue of review for the military legal system. The Attorney General stands at the head of the civilian legal system. In this position, she too enjoys full institutional independence. At all times, the doors to Israel's courts, including Israel's Supreme Court, remain open. This court is widely acknowledged for its willingness to consider issues pertaining to the conduct of hostilities, including ongoing hostilities. Indeed, during the current conflict, the court has already considered petitions on different aspects of the war. Israel's legal system also ensures accountability. The IDF has a robust law enforcement system. It also maintains an independent mechanism for examining and investigating alleged violations of international humanitarian law. This mechanism is subject to review and oversight by the civilian justice system, including the Supreme Court. This system has been structurally strengthened over the past decade, including by consultations with like-minded states and international experts. Assessing incidents in large-scale hostilities outside of a state's territory requires expertise. Our system is provided with substantial resources and authority to fulfill its mission. The military mechanism is already reviewing incidents relating to the current conflict. The rule of law remains a foundational pillar of the State of Israel. The applicant defames not only Israel's leadership, but also Israeli society. Misrepresenting a selective assortment of statements to suggest genocidal intentions and the abdication of core moral values. Israel's counsel, Professor Shaw, addressed this claim. The shock, anxiety, and deep pain that have affected Israeli society since October 7th naturally lead to harsh statements regarding the enemy that is committed to, indeed driven by, destruction of Jews and Israelis. But our legal system knows how to draw a line between statements that may be troubling and even obscene, but fall within the right of freedom of speech in a democratic society, and those statements which go beyond that right. As the Attorney General reaffirmed publicly recently, any statement calling for intentional harm to civilians contradicts the policy of the State of Israel and may amount to a criminal offense, including the offense of incitement. Several such cases are currently being examined by Israeli law enforcement authorities. You will find this statement in tab 16D in the volume. Madam President, members of the Court, a second general matter we alluded to is the broader implications of this application for Israel and the wider international community. As we have shown, this case concerns a large-scale armed conflict with tragic consequences for civilians on both sides. Yes, there is a heart-wrenching armed conflict, but the attempt to classify it as genocide and trigger provisional measures is not just unfounded in law. It has far-reaching and negative implications that extend well beyond the case before you. Ultimately, entertaining the applicant's request will not strengthen the commitment to prevent and punish genocide, but weaken it. It will turn an instrument adopted by the international community to prevent horrors of the kind that shocked the conscience of humanity during the Holocaust into a weapon in the hands of terrorist groups who have no regard for humanity or for the law. If ever resort to force in self-defense against an enemy hiding behind civilians can be portrayed as genocide and trigger provisional measures, an inevitable tension will be created between the Genocide Convention and states defending themselves against the ever-increasing capacities of terrorist organizations. Doing so would also signal to terrorist organizations that they can commit war crimes and crimes against humanity and then exploit this court to obtain protection. For us, provisional measures would lead to a perverse situation. It would effectively allow Hamas to continue attacking the citizens of Israel, to hold 136 hostages in unbearable conditions, to keep tens of thousands of displaced Israelis from returning to their homes, and essentially to promote its plan to massacre as many Israelis and Jews as it can. Madam President, members of the court, in living memory of the atrocities that gave birth to the term genocide, in the aftermath of which the State of Israel was founded, we are witness to a concerted and cynical effort to pervert the meaning of the term genocide itself. The Genocide Convention is too important a foundation in humanity's aspiration to defeat barbarism and evil to be belittled in this way. And the faith that has been placed in international law and its institutions is too cherished an asset to be squandered. We appeal to this court not to be taken down that dangerous road. Madam President, members of the court, for all the above reasons, Israel requests the court, in accordance with Article 60, paragraph 2 of the rules of the court, for the reasons given during the hearing of January 12, 2024, and any other reasons the court might deem appropriate. 1, to reject the request for the indication of provisional measures submitted by the applicant. 2, to remove the case from its list. Madam President and members of the court, that concludes Israel's observations. Thank you for your kind attention.
I thank the co-agent of Israel, whose statement brings to an end the single round of oral argument of Israel, as well as the present series of sitting. In accordance with the usual practice, I shall request the agents of both parties to remain at the court's disposal to provide any additional information the court may require. The court will render its order on the request for the indication of provisional measures submitted by South Africa as soon as possible. The agents of the parties will be advised in due course as to the date on which the court will deliver the order in public sitting. Since the court has no other business before it today, the sitting is declared closed.
Thanks for watching. If you're eager for more, click right here or dive deeper at www.dejobnik.com. Your insights matter to us, so if there's a topic you're curious about, drop a comment below. Don't forget to like, share, and hit subscribe to stay updated with our latest content. Until next time, stay informed and inspired. This is Dejobnik signing off.